Hi, I'm Noah Weisberg.
And I'm Rebecca Rauws.
Welcome to Holland Estates. You're listening to episode number 587. Today we will be discussing, Rebecca, the decision in Re Vaudrey. And for our viewers and listeners out there, it can be found on Canley, and the citation is 2019 ONSC 7551. And we thought it was kind of a neat decision, and it kind of emphasizes the importance of will planning with a lawyer, and what can happen when a will doesn't necessarily contemplate all the instances in distributing the residue of an estate.
Right.
So before we get into kind of the substantive area of the law, Rebecca, perhaps we can just do a quick background of the facts, and perhaps you want to explain who the family members were and what their interests were under the will.
Sure. So our deceased in this case was a testator. He was separated at the time of his death. It looks like, I don't think they were officially divorced.
Right.
So still technically married but separated to his spouse, former spouse. He had 2 children with his spouse.
Right, and they're both adopted, right?
That's right, yep. So the 2 children were Sheila and Kristen.
And for the purpose of today, we're most concerned about Kristen, or the daughter, so
Right.
just so our viewers and listeners know, it's Kristen who we're kind of being mindful of.
Right, perfect. So those are our 4 main characters
Yes.
in this story. At the time that the testator died, his spouse and his daughter Sheila had predeceased him.
Yes.
So that's why Noah says that Kristen is the one that we really care about. She's
Yeah.
the only one alive.
And she's the one who brought the application before the court.
Right. How this all came about was that the deceased had left a will. It was dated 2005.
Yeah.
It seemed to the court that it wasn't done with the assistance of a lawyer, but it seemed to meet the formalities, but maybe not all the I's were dotted and T's were crossed.
Right. So what did the will say about the appointment of the estate trustee and the residue of the estate?
So the will said that, first of all, Sheila should be appointed as estate trustee.
And yes, that's the daughter who predeceased.
That's right.
Yeah.
And she would get the residue of the estate if she survived the testator for 30 days.
Right.
As we know, she did not.
Did not.
So the alternate estate trustee was the spouse.
Right.
And she also was the alternate residuary beneficiary. But again, she had to survive the deceased for 30 days, which again, she did not.
Right. So here we are, stuck with the will, where the bequests regarding with respect to the residue that the deceased wants to make can't really be performed because both of the individual has predeceased. So what one would normally do at this point is try to read on for the rest of the will to see what happened in that instance. But in this case, there was nothing,
Yep.
right? So Kristen, the daughter who survives, brings this application, and what's the relief that she is seeking?
She sought a couple of things. I think the most interesting one is probably what we've been hinting at so far, but basically she sought a determination as to whether the will was valid,
Yeah.
because it was kind of wonky, whether she would be appointed as estate trustee, and who would inherit the residue of the estate.
Yeah, and I just think 2 quick things regarding issue number 1 as to whether the will is valid I want to bring up, then we can kind of get into what to do with the residue, was that there was no affidavit of execution, and that's something that normally a lawyer would assist a testator in preparing to make sure that the witnesses were present when the will was signed. And secondly, something that we don't necessarily always see in our practice, the Sheila was both a beneficiary and a witness to the will. So in that instance, the Succession Law Reform Act would void, doesn't void the will, it just voids the gift or the bequest to the witness. So the court was very careful in drawing the distinction that, hey, the will is valid, notwithstanding that these minor things which probably made the ability for Kristen to proceed just one more hoop she had to go through.
Right.
So let's get on to the residue. So what does the court say? What do we have to be mindful of, when we have a will where there is nothing left with with no beneficiary for the residue?
So when the will doesn't say who the residue should go to, or it does, but it doesn't work out, then the court says that we have to look to the intestacy rules set out in the Succession Law Reform Act.
Right.
And there was also, while we're talking about this, there was an interesting term in the will that the testator actually wanted to disinherit Kristen.
Right.
He said they were estranged, and he said under no circumstances should any money go to her, and the court considered the impact of that when it
Right.
was interpreting the intestacy rules.
Right. So the court basically said that because there was no one left to give the residue to, it would pass on an intestacy. Importantly, because the spouse had predeceased and the other child had predeceased, yet she had no issues, there was no grandchildren, that the entirety of the estate would go to Chris on an intestacy. And although the deceased had written in his will they didn't want her, Kristen, to receive anything, the court was very clear to say when you can't oust the intestacy provisions of the SLRA. So here we are, Kristen going through all these hurdles, all these steps in order to get her inheritance. You just would have hoped that had there been a lawyer involved, that would have mitigated some of the hoops that had to be jumped through, and probably would have limited the legal costs as well.
Right. Although on the other hand, if there had been a lawyer involved, then they might have made a gift over provision, and Kristen wouldn't have gotten
Still would have gotten
anything.
nothing. Yes,
So.
yes. So we'll never know, right? So perhaps that's a good point to stop. This concludes our podcast. Until next time, we want to thank you for listening. I am Noah Weisberg.
I'm Rebecca Rauws.
Should you have any questions, please email us at webmaster@hellandhello.com or leave a comment on our blog. Thank you, Rebecca.
Thank you.